Good morning. Kindly carefully read the judgment which I am going to refer, which will help you not only in the family court case. You can adopt this case in various other provisions, DVC, 125 CRPC, family court other matters, and also, if possible, other criminal matters like Negotiable Instrument Act, etc. It's a case of AR 2023 Andhra Pradesh 20. AR 2023 Andhra Pradesh 20. Munavat Jairam Nayak versus Munawata Sri Usha. Their interesting question of law was raised when Hindu wife filed an application under Section 18 of Hindu Adoption and Maintenance Act. Section 18 for maintenance. The objection was raised stating that since husband and wife belonging to scheduled tribe, in view of family court, that Hindu Adoption and Maintenance Act, the act only applies if the state government notifies a gazette that this petition is the scheduled tribe, a particular scheduled tribe is brought under Hindu Adoption and Maintenance Act. Therefore, what had happened, so that you should keep in mind that in view of that provision, they have under Section 2, subclass 2 of the Hindu Adoption and Maintenance Act, not applicable to community of the scheduled tribes unless notification issued by the central government is published in the official gazette. Therefore, the wife filed another application 125 CRP for application under order 6 Rule 17 CPC to convert that person as a CRPC. So that was allowed by the lower court. Therefore, aggrieved husband filed an application before Honorable High Court. Honorable High Court, Andhra Pradesh, AR 2023, Andhra Pradesh 20. This was delivered by B.S. Bhanumati, Justice B.S. Bhanumati. She has very well settled the law by reading Section 2 HMA Act. Then they say because they do not dispute. Then the question arises whether the transfer application, conversion application under Order 7, Rule 17 would apply or not. Then they have read Section 7 of the Family Court Act deeply at paragraph 10. Then they have read Section Section 10 of the Procedure of the Family Court Act. Kindly read Section 10 of the Family Court Act, every provisions, so 1, 2, 3, deeply, so that it will help you always, because it lays the what shall be the procedure for the family court to decide the case. Then they have also discussed about Chinnappayan versus Chinnattai case, criminal RC decided by the Madras High Court, and they have also discussed the Supreme Court judgment in Sugandhi versus Rajkumar. Then they have discussed about various other judgments. Finally, they held, see, there is no prohibition for the family court to convert this Hindu Maintenance Adoption Act application under Section 18 for maintenance as 125 CRPC. So, since there was no specific bar, they say the Family Court Act Section 10 and the Order 7, Order is applicable. Order 6, Rule 17 and 151 CPC is applicable. Therefore, they hold good that the Family Court has got power to convert this maintenance application as application filed under Section 125 CRPC. So, kindly go through the judgment and be thoroughly go through the judgment, every paragraph, so that you can understand the family court proceedings and how the complicated question of law are being dealt by the honorable judges. Best wishes. The other day, I have communicated a order seems to be passed by one district judge, senior most district judge. See, everybody has noticed that the contents of the order, but they did not notice that at the top of the order, they have stated some irrelevant police station. Criminal MP in N1 Rayapuram police station. That means the typist, the computer attendant seems to have typed the order by pasting. So it's normally happens. They did not concentrate. Subsequently, when they have typed a particular police station, N1 police station, they forgot about what is in top has to be amended. Okay, that is fault of. But unfortunately, the judge or the other stops authorized to have second check or that did not notice that order is having a cryptic contents. Whatever it may be, it is not the first time I have noticed the order. On earlier occasion, I have noticed 2 or 3 orders wherein very unfortunate finding of the court while granting some relief. Relief was granted, but unfortunately that was not, whatever it may be, I hope somebody should take care to inform the particular judge about second check of the orders. I am requesting all the others also to see before at least sign or at least have second check over the orders. There may be possibility of delay for that, but this is unfortunate. Okay, that's all right. The another thing was, the problem was the Honorable High Court is superior to district courts. Honorable High Court granting bail, anticipatory bail, if it is filed without a crime number, that means unknown crime number. Subsequently, if the PP reports that the crime number and offences it is being incorporated, that is was earlier happening. Sometimes it was being dismissed, directing us to file another application after that. That is, you are burdening the cost of the state government, because for every bail application disposal, the government has to pay fees. Unnecessarily, the courts are burdening the loss of exchequer without any logical meaning. Therefore, but the lower court simply saying another aspect, this is nothing but a procedural harassment, violative of fundamental rights, because the CRPC mandate the police officer, if FIR is registered for cognizable offence, it should be forwarded to nearest message in 24 hours. In our case, it was not forwarded. That was our grievance. Still, public prosecutor hand over the FIR, only uploading that FIR after 7 days. This is some sort of procedural harassment being endorsed, licensed by the judicial process. Very unfortunate. Something should be done. The legal luminaries may take this matter to judiciary and also the higher authorities, so that the FIR, if it's not filed within 24 hours, the judge should jump or pass some strictures on the police officers. And they are bargaining with that FIR. This is too other much unfortunate. What can I do? I can only circulate it. Say, if these are, we can't, for simple reasons. One thing is, because of heavy rush before the courts, if we start intervening in these applications, other junior advocates may say that our matters are held up, and they may not realize my endeavor or my approach to clear certain doubts with the judiciary, so that they will continuously get proper benefits. Unfortunately, this is what had happened. That's all right. It is order of the day. Let us hope a fine day will come. to put an end to all this procedural harassment being caused not only to the client citizen of India and also to the counsels who are appearing for the accused. Best wishes.